Namaste doston. Today I am going to talk about one of the most historic and powerful cases in Indian constitutional history, Keshvanand Bharati versus State of Kerala 1973. ये केस ने इंडियन डेमोक्रेसी की डायरेक्शन बदल दी थी. इट डिफाइंड हाउ मच पावर पार्लियामेंट रियली हैज और किस हद तक वो कॉन्स्टिट्यूशन को बदल सकती है. Facts of the case are: the story begins in Kerala. Swami Keshvanand Bharati, the head of Edneer Mutt, challenged the Kerala government's Land Reforms Act of 1969. गवर्नमेंट ने उनके मठ के कुछ लैंड को टेक ओवर करने का डिसीजन लिया था अंडर द आइडिया ऑफ लैंड रीडिस्ट्रीब्यूशन. स्वामी जी ने आर्ग्यू किया दैट दिस वायलेटेड हिज फंडामेंटल राइट्स, स्पेशली अंडर आर्टिकल 25 freedom of religion, Article 26 freedom to manage religious affairs, Article 14 right to equality, Article 19 1F right to property, which existed at that time as a fundamental right. उन्होंने ये भी कहा कि गवर्नमेंट को इतना अनलिमिटेड पावर नहीं होना चाहिए कॉन्स्टिट्यूशन अमेंड करने का. The main constitutional issue was, can Parliament amend any part of the Constitution, even the fundamental rights? क्या ये पार्लियामेंट की पावर भी लिमिटेड है? Basically, the question was, is there any part of the Constitution that cannot be changed, even by Parliament? The case involved these key articles. Article 13, laws inconsistent with fundamental rights are void. Article 368, power of Parliament to amend the Constitution. Article 25, 26, 14, and 19, fundamental rights claimed to be violated. Earlier cases like Shankari Prasad 1951 and Golaknath 1967 had given opposite views. एक कह रहा था पार्लियामेंट कैन अमेंड एवरीथिंग, दूसरा कह रहा था fundamental rights cannot be touched. So the Supreme Court had to settle this once and for all. Judgement. The case was heard by 13 judges, the largest bench in Indian history. After 68 days of arguments, the judgment was delivered on 24th April 1973. The verdict was 7 judges versus 6 judges, a very close call. The Supreme Court held Parliament has wide powers to amend the Constitution under Article 368, but it cannot alter or destroy the basic structure of the Constitution. This means Constitution को बदला जा सकता है लेकिन उसके कोर वैल्यूज नहीं, जैसे कि सुप्रीमेसी ऑफ द कॉन्स्टिट्यूशन, रूल ऑफ लॉ, सेपरेशन ऑफ पावर, जुडिशियल रिव्यू, फंडामेंटल राइट, सेक्युलरिज्म एंड डेमोक्रेसी. इन सब को डिस्ट्रॉय नहीं किया जा सकता. ये प्रिंसिपल को हम कहते हैं बेसिक स्ट्रक्चर डॉक्ट्रिन. What is the importance of this case? The Keshvanand Bharati case is known as the guardian of the Indian Constitution. It protected India from turning into a dictatorship. If this judgment had gone the other way, Parliament could have removed fundamental rights or changed democracy itself by amendment. इसलिए आज भी जब कोई गवर्नमेंट अमेंडमेंट करती है उससे चेक किया जाता है, डज इट वायलेट द बेसिक स्ट्रक्चर. अगर हाँ तो सुप्रीम कोर्ट उसे अनकॉन्स्टिट्यूशनल डिक्लेयर करता है. सो इन सिंपल वर्ड्स, द केशवानंद भारती केस ensured that the constitution remains supreme, not the parliament, not the government. It gave us a balance between sorry, it gave us a balance between change and stability. As the judges said, you can amend the constitution, but you cannot destroy its soul. And the soul is the basic structure, the foundation of our democracy. Thank you. This was the story of how one monk, one case, and one judgment saved the spirit of Indian Constitution forever. Please like, share, and subscribe for more such videos. I'll be bringing on more case laws like this.